Hi, everybody, and welcome to Raw Law. This is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and this is the show where we answer your questions and we talk about your comments. So it's live. We're here in my office in beautiful Bensonhurst, Brooklyn, and had a pretty good day today. I've been, working on cases, did a few consults with people, and tried to answer their questions, and we had a good few nice conversations. And so welcome everyone. So let's get right into it. Let me start answering questions. So the first question I see is from Brandy, and she says, "Hello, Mr. Arkady. I was hit by an 18-wheeler in Texas with a 1 million policy, and there are 3 herniated discs in the neck, 3 steroid injections in the neck, and the back recommended surgery, but not taking. How much is my case worth?" Okay. And there's 80,000 in medical bills. So, I mean, look, if you have an 18-wheeler, you're not at fault. There's $1 million in coverage. The first thing I would do is I would say, look, see if there's any excess or umbrella, because sometimes the 18-wheelers, especially if it's a company that has multiple trucks, they're called power units. They might have like 30 power units. They're not just going to have $1 million. They're going to have $1 million with like a 5 million umbrella, or $1 million with a 10 million umbrella, So you want to find that out, because then you can make your settlement larger. But if they really only have $1 million, that's usually trucks that only have one owner operator, like one truck, maybe 2 trucks and no more. Those could be $1 million or even 750. And if that's the case, but you have 3 herniated discs with epidural steroid injections, and you have the need for back surgery. So, I mean, just that right there, the fact that you have 3 herniations, you've needed epidurals, that could be worth like, 200,000-300,000, but you have 80,000 in medical bills. So that also has to be factored in, right? That's worth more because of that. And then the fact that you need back surgery, what I would do is I would then get a report from the surgeon, a narrative report, right? Saying this particular patient needs back surgery and it was caused by the truck crash. Now you have it in writing, and then it's medically known that if you will have the surgery, you might not want to have it now, but you might have to have it in 15 years, right? In 20 years. Now that back surgery costs like, $200,000, but no, wherever you have it, let's say you have it at the L4 level, right? Well, it's medically known that you also need it at the L3 level in another 10 years, right? Because that's known as adjacent segment disease. So you need it at the next level. So now that's another 200,000. And then what about the other level, right? L4, there's also L5. So you go L3 and L5, those 2 levels. So now you're talking like 600,000, right? Because each surgery. But guess what? It's not just the surgery. You also need prescriptions. You need physical therapy. You need MRIs. So just the costs on something like that could be into the millions, right? And then what about the pain and suffering and the loss of enjoyment of life? I think those are the biggest categories. So you put that all together, it could be a big case, but you have to make sure you have the right attorney, like a real trial attorney who knows how to build it and knows how to present all the categories and say, look, this is past pain and suffering, future pain and suffering, past loss of enjoyment, future medical costs, past medical costs. And then when you add it all up, it could be huge. But a lot of lawyers, they don't really do it that way, right? They just kind of say, oh, I want to settle the whole case for like 300,000, but why? You can get a lot more, right? So that's the thing. So if you need a consultation, just text me. It's 347-566-9595. I had a lot of consults like today. I think I did 2 or 3. I'm going to try to do like 2 or 3 a day. I know some people are still waiting. I haven't gotten to them, but I'm going to get to you by the end of the week. I'm sorry. I'm trying, because last week I had depositions and they took the whole day. I did a video about it. It's going to come out in a few days, maybe next week. It was actually funny to me because they were both really big cases. Like one was a truck crash with a brain injury, and the other one was a truck crash with like multiple surgeries. But like the questions they were asking were like absurd. They were asking, like, for example, one of them was driving a Honda from 2022, and they asked him, is your Honda equipped with turn signals? He's like, yes. I mean, of course, right? And they keep the person there for like 7 hours, because that's the maximum you can have. You can't go more than 7 hours. But from like 10 a.m. and it goes to like over 5 p.m. And asking questions like that. Like, do you have turn signals? Of course I do. No, I have the one Honda that doesn't have turn signals. Like, and it's just like a waste of time. But then I was thinking, why are they doing this? Maybe they're just trying to, wear you down, kind of like attrition. Like, wear the injury victim down, because then by the end of it, you'll be so tired. You'll be like, you're asking me, were my windows tinted or whatever, some stupid thing. And then I'm like, oh, I don't care anymore. People get mad and just, but no, these clients didn't, luckily. The depositions went really well, but it's just, I was stuck in there for like all day. I felt like I was in prison or something. It was terrible. I wouldn't want to do depositions like every day like that. I'd go nuts. It's just, I don't get it. But anyway, that's a different story. So let me go back to the questions. I'm a Beam says, hi, Mr. Arkady. I have an orthopedic IME this week. Any advice? Yeah, absolutely. What I would recommend is, go to the IME, have your lawyer bring someone else, like a watchdog, to the IME, and that person can then sit there with you and record everything. Like some states, they might allow you to actually audio or video record. Do that if you can. Some states like New York, I think they don't allow that. But if you have the watchdog, they're just somebody else who's an independent observer, and they're in the room and they're watching, right? So then if the doctor writes a narrative and says, I spent an hour with this patient, no, the watchdog is there. He goes, exam started 11:01, exam finished 11:11, whatever. So it's only 10 minutes, right? And everything he did this test, he did that test, and everything is documented. And then you can call them as a witness at trial. But other than that, there's not really much I could say. Just, go there. You have to go, tell them honestly what you can't do. But they write those reports very, very one-sided. There's nothing independent about them. They're really defense insurance company doctors that have the same report already printed, and they just change the names. And they say, hey, this is not from the crash. This is from living your life. This is degenerative disc disease. They already have it all written. So it's like, why even go to the exam? But it's like a game they play. Okay. And then Manny says, hello, Arkady. I would like to speak to you. I had sent you a message. Yeah, just text me again. I could speak to you probably tomorrow, Thursday, or Friday. I'm trying to do like 2 or 3 a day. I just can't, can't spend the whole day doing the consults, unfortunately, because I have other obligations like court and depositions. And now I have to prepare for a trial, because now we have a trial. On May 19th, we have a trial in the Bronx, also a brain injury case. We're doing a lot of like brain injury work. And I was out in San Diego. I think I talked about that before with the traumatic TBI Med Legal, the traumatic brain injury conference, and I learned a lot. And actually, I want to do a video about that, because I actually took notes on one of these, like a Kindle Scribe. You could write on it. I took notes in there. So I want to review those and do a video about that, because I learned a lot about brain injury, and I think that would be interesting for a video. Okay, and then Sengiz says the defense side has already extended the discovery deadline twice, and now they've applied for a third extension. How many more times are they allowed to request an extension? I also went to their doctor for the IME. They're requesting another extension using the excuse that their expert reports are not ready. Yeah, well, I don't know like what state you're in, or, it depends on that, right? And what judge you have, but you should ask your attorney. I mean, usually it depends what they're asking to be extended. If they're asking like the discovery deadline to be extended, they have to show good cause, right? So usually that's not so hard to do. So the judge might give them like 1 extension, 2 extensions, but after a while, the judge might say, you know what, that's it. So you just have to ask your attorney, and don't let them, keep extending forever. But they don't really usually, do that. They don't usually keep extending forever. Usually it's like a few months here and there. But yeah, you just have to kind of shut it down. And if there's no good cause, if there's no reason, then you just have to say, you know what, you've had enough extensions. Make a motion and say, look, I'm okay with having a deadline, but let's make the deadline like in 60 days, and that's enough time. 90 days, that's enough time, and that's it. Otherwise, right, they just keep extending forever. It's like your case never sees the light of day. Okay. And then David says, does a pre-existing injury affect settlement? Yeah, I mean, it does, in the sense that if you have a pre-existing injury, you have to, discuss it. And then if you've already had an injury and, it depends on how you look at it, right? On the one hand, the defendants are going to say, well, we didn't do this, right? Because you already have an injury. So your injury is not from this crash or this fall. Your injury is from what you had before. So you have to be able to distinguish it and say, look, I had X, Y, and Z before. So because I had X, Y, and Z before, I'm already more vulnerable. And the defendant takes an injury victim as he or she finds them, right? So some injury victims might be like bodybuilders that have muscles that are super strong. You hit them, nothing happens. Other injury victims might have pre-existing disc disease. They might have, bulging discs, herniated discs. They might have whatever issues, right? They might have had shoulder surgery before. You hit them, they fall on the shoulder. Well, now they need 2 more surgeries or maybe a total shoulder replacement. But it doesn't say that you get to hit people that are already vulnerable and hurt them and get away with it, right? You have to pay for all the damages you cause. Just like if you go into a store, right? If I go into a nice store like a Cartier or a Tiffany and there's some kind of Tiffany egg, it's like a $30,000 egg. I knock it over, I break it, I got to pay $30,000. If I go into another store like a dollar store, I knock over a plastic egg, nothing happens, I don't pay anything, right? But I can't say, oh, I should have gone to the plastic store, so because I went to the Tiffany store, I shouldn't pay the $30K, right? That doesn't make sense. That's crazy. So it's the same thing with pre-existing injuries. It's just like, but the amount that you can recover is to the extent that you make the injury worse. So if you already have an injury that's not caused by the accident, if the accident doesn't make the injury worse, then it doesn't matter, right? Then you can't recover. So it just depends on how you, how each case plays out. So we always try to maximize recovery using that's basically what I just told you is kind of like what the law is. So we always try to build the case according to the law to get the maximum recovery. But I love pre-existing condition cases. I'm not worried about them. And Dasani says, good day, Mr. Arkady. What happens after a deposition? So usually after the plaintiff's deposition, your lawyer will then also ask questions of the defendant, right? And then a deposition to establish liability or whatever evidence your lawyer has to gather. And then you certify the case as trial ready for the most part. There might be an IME after the deposition, but usually you can get close to certifying it as trial ready. You go on the trial calendar, you wait, at least in New York, and then you get a trial date. Other places, I think you get trial dates earlier, but like, for example, I think in Florida, you get like a trial date right when you file a lawsuit, or California, but it's still not, that much closer to when you file a lawsuit. It's still going to be like a year, 2 years later, and it could be adjourned. So it just depends on your state. But yeah, usually that's like the last step, depositions of all parties. You exchange documents. That's the entire process is known as discovery, right? Because you're discovering information. So you have questioning witnesses, non-party witnesses, as well as the plaintiff, the defendant, and then exchange of documents. And then when that's all done, that's the end of discovery. Then you have the trial. And then while you wait for the trial, you might have pretrial conferences, settlement conferences, all that kind of stuff. Okay. And then Manny says, what will happen if my attorney demands a quantity that I'm not satisfied with? Can I let him know that I want the full amount of whatever the insurance has with the extension? 4 surgeries, 3 cervical and rotator cuff with an anchor, and $5 million in excess. Oh yeah, of course. I mean, your attorney should not be demanding an amount that you're not happy with, right? Because your attorney is like your guide. You hired him to represent you because you're not a lawyer, right? But you're the client, right? So it's your case, it's your money. So you got to tell him, I want, $5 million on the case, whatever you want. He can't go in and demand $1 million and be like, I got you $1 million, take it. No, you don't want $1 million, you want 5, right? So you got to just tell him. But yeah, you said you wanted to speak to me. So maybe I'll give you a call, maybe even later today or tomorrow for sure. Just text me again because I get so many texts. So I don't always, I have to get a better system to manage them, and maybe because it just kind of comes in and it's hard for me to track everything. I'm going to try to get a better system, or maybe get one of my paralegals to help me and schedule everything. But yeah, definitely. If you have those kind of injuries, I'd be happy to, help and speak with you or whatever you need. Okay. And then C Note says, my coworker fell on me from a scaffold in Great Neck. I'm trying to pursue a labor law 240. I've been off work since August 1st and finally just decided to get the ACDF, which is the anterior cervical, the neck, the cervical discectomy and fusion. That's a major surgery. And I was on the ground when my coworker fell. My lawyer has yet to give an update or an estimate, and nothing on E-Case Civil Supreme, and we filed shortly after the injury. So your coworker fell on you from a scaffold, and you're pursuing a 240 case, and you've been out of work, and you're going to have this ACDF. I mean, it sounds like a good case. You'd have to see like what the theory is of if it's like a a major construction where they're building like any kind of commercial building or apartment building, yeah, then you'd have the GC would be liable, the general contractor, as well as the owner. That's 240. 240 is gravity related. So you'd have to argue that the worker fell because of some lack of a safety device that they should have had. So scaffolds, maybe something was wrong with the scaffold, something was unsafe. You get an expert, like a safety engineer that knows the industrial code and knows the labor law. But a 240 case is a slam dunk because you get liability as soon as you show it's gravity related, right? So the force of gravity upon the, I guess the worker that fell is what caused the injury. And then it's not workers' comp because you sue the owner of the job site, right? The landlord of the whole thing. And you sue the GC, right? The general contractor, who's probably not your employer. You might have a subcontractor as an employer. And with those injuries, that could be like a $5 million plus case. So I don't know why they're not moving it. You know, it's hard for me to say, but just text me 347-566-9595. And I'm happy to chat about it and, you know, give you some advice and help if you needed my help. I do a lot of those cases. I like those cases. I'm actually working on one right now in the Bronx, a labor law case with massive injuries. I'm trying to get the client more because also the prior lawyer wanted to get him like, I forget how much, but it was low. It was like maybe $1 million or $2 million, and I think it could be like 10 million or more. So I'm trying to really build it up. You know, that's what I like to do. I like to get maximum on the cases. And Argel says, "Hi Arkady, I am going on my 3rd surgery for a spinal fusion. We are now on a lawsuit phase. Policy is $8 million. I'm 39 years old and was hit by a semi-truck while I was sleeping in the back. Will it go beyond the policy limit of what my lawyer is asking for?" Yeah, I mean, possibly. It's hard to say. You know, you have your 3rd surgery for a spinal fusion. So you needed 3 spinal fusions, 3 different ones, or was it like revision of the original one? But either way, I mean, that's, you know, I'm sorry to hear that. That's a real serious injury because a spinal fusion is already serious, but to have 3 of them, that could be really big. And then, so you're in the lawsuit, the policy is $8 million and you're only 39. And if you're hit by a semi-truck, of course, you're entitled to, like we talked about earlier in this video, you know, all those different elements of damages, like your lost wages, pain and suffering, future medical costs, loss of enjoyment of life. There could also be other damages. So yeah, it could be really big. I mean, whether or not it goes beyond the 8 million, you know, it's hard to say whether you're in a state that allows for like bad faith. If you open up the policy, like if you send them a letter and say, look at all this evidence, look at my lost wages, look at my injuries, you know, pay me, if you have 8 million, pay me the 8 million, you have 30 days. If you don't, then I'm going to go to court and I'm going to tell the jury that civil justice in this case is 20 million, right? And what if the jury agrees with me and gives me 20 million? Who's going to pay the other, right? Above the 8, who's going to pay that? Those 12 million above the 8, who's going to pay? It's going to be this trucking company. And the trucking company shouldn't have to pay because that's why they bought insurance, right? You have to pay. And I'm giving you the opportunity to then resolve it within the primary policy limits. But if they choose not to, then you can get into the excess by opening up the policy, and it's known as bad faith. So also just text me because I'm happy to do a consult with you and discuss, because, you know, and I don't know what state you're in and things like that. So you probably need a little bit more of a consultation for me to do that. But I'm happy to do that. Yeah, absolutely. So yeah, that's sometimes unfortunately I just can't, you know, answer the question based on the comment because it's not enough information, but I'm happy to do a consultation because I want you to get the right answer and help. Yeah, absolutely. Yeah, let me see here. So the next one is from C Note again, and he says, does the building value play a role? Where I got hurt in Great Neck, the building has every unit at 500,000. They're co-ops. Oh yeah, that's good. That's good. Yeah, that means they're gonna. I mean, it doesn't play a role directly, but it does play a role in the sense that, look, if you got hurt on like a 1-family house, right, the whole building is only worth like 300K. It's going to be hard. They're probably going to have very low insurance. They're going to argue the 1-family exclusion under the labor law. So it's much harder if you have a big, you know, apartment complex like that where every condo is 500K. The whole unit could be worth like, I don't know, 20 million or more. They're going to have large policies, which is good, because when you have a large policy, then, you know, in a labor law like that with a 240, all you have to prove is damages, right? Because you're going to have liability on summary judgment usually. So then you can prove damages. And if you do prove, all those different elements like we talked about, especially the pain and suffering and the loss of enjoyment of life, those are the biggest elements. But then you're going to have lost wages, you're going to have future medical costs, and then you build all those up. You might even need to get like a life care planner or definitely an economist. And then it becomes, a big case. That's why some of those cases settle for like 20 million, 15 million. And those are settlements, not verdicts, meaning like, you get a verdict and then they say, oh, you got pie in the sky, 100 million, whatever. We're going to appeal. We're going to lower it down. You're not going to get that money. But settlements, people are actually like settling those cases for like 25 million, 15 million, and actually getting, it's like, settlement obviously is a contract. You're actually getting the money within like 30 days. So yeah, those could be huge cases. And then C. Hampton says, hi, I had a workers' comp hearing last month, just found out this morning. The judge approved in my favor. The insurance company denied my case 11 months ago, slip and fall, 2 vertebral fractures, concussion. Oh, I see, okay. No, I mean, that's good. If the judge ruled in your favor, that means it's going to be approved, right? So you're going to be able to get you're going to get the comp benefits. I mean, my understanding of comp is you get your lost wages paid. Oops, sorry, I have something in my. You get your lost wages paid, so that's good. And then you also get your medical bills paid, which is really a big deal too. So you want to get your medical bills paid. But when you get your medical bills paid, it's basically money going to doctors. Obviously, that's not you. It's money going to other people. So it's nice, but it doesn't really give you anything. So with workers' comp, you want to get your lost wages because that's actual money to you. And then in New York, there's something known as a Section 32 settlement where you can get a lump sum, and it's usually like a big amount, and not as big as personal injury, but a big amount. Like people get lump sums of like 300,000, and then you get that for yourself. So you can do that as well. Okay, and then Argel said surgery that was done, microdiscectomy, nerve ablation. Third surgery is the spinal fusion. Oh, I see. Okay, so you had the micro. Well, that makes sense, right? Because you're going step by step. First, you try the micro, which is like the percutaneous discectomy. That case is usually worth about like 300, 400, maybe 500,000. But you did that. Then you go for the ablation. That also could be worth like a few $100,000. But and then because those failed, you need the full-blown fusion, L4 and L5. So 2-level fusion. Yeah, that's a huge case. That could be a huge case. So it just has to be built up the right way. And C Note says, I'll text you. Yeah, please text me. I'm happy to help. And then Nayslayer says, Konnichiwa Arkady-san. Policy limits 300 plus 1 million. The first offer was 325. Does this tell you that they are playing hardball? How would you negotiate them to tender the 1.3? It's a DUI with an ACDF and a C5, C7. And he says, arigato sensei. Oh, I like that. Yeah, I like the Japanese things, I like the sushi. I like the, I haven't been to Japan, but I want to go. Maybe soon I'm going to try to go. I love the Japanese culture. But anyway, yeah. So let's see. So you have the first offer of 325, but you want to get more. I mean, the way I do it, like I talked about before, is I would just send them a letter and I would say, look, pay me the 1.3. You have 30 days. Give them everything, right? Give them all your medical records, ACDF, all your bills, whatever you need to give them. Tell them a little bit about you and your biography and how it's impacted your life. Maybe even have a few photos in there or witnesses. Like I'm going to have, you don't have to give them the names of witnesses, but you could say my friend is going to testify. My friend Bob is going to testify. My friend Cheryl is going to testify. My coworker Ronnie is going to testify, and then what they're going to testify to. Like give them everything, right? And then just say, look, and this is why, and your guy was drunk, and the jury's going to hate that, and I have an ACDF, so pay me the 1.3. You have 30 days, pay me by May, 29th or whatever at like 5 p.m. And look, if you don't, that's totally fine. But guess what? May 29th at 5:01, it's not going to be 1.3 anymore. It's going to be like 1.8 or whatever you want, whatever your lawyer feels comfortable with. And then who's going to pay the difference, right? If the jury agrees with me and gives me 1.8, well, that's 500,000 more than your limits. So who's going to pay that 500 then? Is it going to be Mr. Robert Smith, the guy who got drunk, had too many Budweisers and crashed into me that day? Okay, well then Mr. Robert Smith doesn't have 500,000 sitting in the bank. All he has is money for another Budweiser. So it's going to be whoever the insurance company is, State Farm or, like a good neighbor or Allstate, you're in good hands or whatever, Geico, the gecko is going to pay. Someone's going to pay. It's going to be you guys, right? So you make that argument and then you tell the judge this is bad faith because they had an opportunity to settle within the primary limits, the 1.3. They chose, right? That's a choice. They are choosing not to pay within the primary limits. And why? Because they want to save their money. They think they can get away with paying less. But they have a duty to their policyholder, to the insured, Robert Smith, the guy who loves the Budweiser, right? They cannot say that, hey, we are, let's say, State Farm, Geico, Allstate, they can't say like, F Robert Smith, we just want to save our money. They can't do that, right? They have to put Robert Smith's interests on an equal footing with their own interests. And if they fail to do that, right, if they put their own interests higher, well, then that's bad faith. The courts have said that. So you just have to your lawyer should look at bad faith law in your state. But that's totally like, they should tend to that. If it's like an ACDF, they should just tend to that. Absolutely. I hope that helps. But yeah, absolutely. And then SD says, what about PTSD, neck, upper and lower back injuries, loss of business contracts? Lawyers say they're putting together a demand letter, but they have other cases before mine. Yeah, I mean, PTSD, well, that's one of the things I wanted to talk about, like from the conference. PTSD could be as valuable as a TBI. I actually did a video about it. You could watch that on YouTube. But yeah, they were talking a lot about PTSD at the brain injury conference, and PTSD is the post-traumatic stress disorder. And there's a lot of ways that brain injury affects, your emotions, right? Whether you're happy or sad. A lot of brain injury victims, what happens is, they were happy before, they were very vibrant, they're doing things, whether it's in their business, in their personal life, whatever, right? Friends, passions, right? They might want to go, I don't know, play tennis or snorkel or whatever it is, right? There's millions of things you can do in the world, ski. But then after the brain injury, they become more recluse. They just stay at home. They're dark. They sleep a lot. They don't want to go anywhere. They can't, right? Because like they go to the movies, they can't because the lights, the sounds, they can't take it. They have to leave. So yeah, if you have a real like PTSD case, that's as valuable as a traumatic brain injury. That could be like huge. That could be many, many millions. And I don't like the word demand. I don't like to make demands. I like to give them the opportunity to settle. So you review the case, you see what you think it's really worth. If it's worth $1 million, you say, hey, pay me the $1 million. If you don't, that's fine, but give them a deadline. And then boom, if you don't pay it, guess what? It's not $1 million anymore. Now it's $2 million or whatever you feel like it. But your lawyer has to be, you can't just like say that and then not follow up. You have to then be willing to go to trial and stick it to them kind of thing. But yeah, that's a huge case. So yeah, text me as well if you need any further on that. I can help you. What I've also done for some people, like if they have a lawyer but they're not sure, is I could do the verdict search and then send people the results. Like for example, the lawyer's prior settlements, their prior all their prior verdicts that they had. Some people, what they say, oh, I've gone to court, I have all these verdicts, but the verdicts are nothing, right? They don't have any. Other people really do. They have nice verdicts. Like I was speaking, I forget who it was, but one gentleman and he had a lawyer, and the lawyer had nice verdicts, like a verdict for like $8 million, a verdict for $3 million. So I told him, well, you're in good hands. So whatever it is, I'll just tell it like it is, So I could do that as well. Okay, and then One Love says, after a deposition, after 3 years in an elevator accident at work, cervical fusion, shoulder cuff surgery, back discectomy, do they offer me a settlement after deposition? Yeah, I mean, I think so. I mean, they should, right? But that's the thing. They just choose sometimes not to be fair, which is like the craziest thing. But if they choose not to be fair, what you have to do is just have a real trial lawyer, take them to task, go to trial against them, hit them. What else could you do, really? And he says, the lawyer tells me to settle my workers' comp at the workers' commercial building, 51 floors. Oh, it happened in a commercial building. Okay. I mean, it sounds also like a good case. Well, today everyone seems like they have like I don't know if it's me, but maybe but it seems like everybody who's chatting, it seems like to me like everybody who's chatting has like a multi-million-dollar case, because these all sound like amazing cases. But yeah, I mean, if you had a fusion, shoulder cuff surgery, I mean, I think fusions could be worth many, many millions, as long as, you have liability. If you have a third-party lawsuit, if you have liability, it's good. If it's just workers' comp, it's also significant, of course, but then you're limited to lost wages and medical bills, and plus maybe the Section 32, the lump sum for yourself if it's New York. But yeah, feel free to text me. I'll chat with you about it. I'd have to know a little more to give you more insight, but it sounds like a great case. And Nayslayer says, I just watched The Karate Kid. Oh, okay. Yeah, that's one of my favorite movies. That's a great movie. And now they have that Netflix, the Cobra Kai, right? So that's pretty good too. But The Karate Kid, Mr. Miyagi, that's a great one. Okay, David says, is it possible to get a 1 million plus settlement from getting RFA, that's radio frequency ablation, and medial branch block injections with no surgery involved, with also PTSD diagnosed? Yeah, I mean, if you didn't have the PTSD, I would say no, because RFA and medial branch blocks, I mean, medial branch blocks really aren't worth much. RFA could be worth, a few $100,000 possibly, if the RFA, is the only, because basically what you're doing is you have the herniated disc, right? I could show you what an RFA kind of is, or explain it. Like if you have the herniated disc, right, like this red part, and then for whatever reason, if you can't remove the herniation from the disc, like you can't do the percutaneous discectomy, the radio frequency ablation, what they do is they kind of burn the nerve. So you have these nerves going everywhere, right? And the nerves are also, smaller nerves are on the vertebrae, on the bone. So they're everywhere, the nerves. So instead of getting rid of the herniation for whatever reason, medically, maybe they can't. So they just burn the nerve. They burn it so much that, they get rid of it so you don't feel the pain, because if they don't burn the nerve, you're going to be in pain. So it's kind of like a serious thing, but it's a procedure, and so you can't just get a value for the procedure. What you want to do is get a value for what the procedure is kind of doing to you. So for everything, for the procedure, for the fact that you're hurt, for why you need the procedure, the fact that you're going to need future procedures, but the whole thing, yeah, it could be worth a few $100,000. But when you have the PTSD, if you're really seeing a psychiatrist, psychologist, and then you need like a little bit of a deeper dive. Sometimes you want to do, scans like the diffusion tensor imaging, have a neurologist, have a neuroradiologist, have a neuropsychologist. But yeah, the PTSD could be as big as a brain injury. Then it could totally be $1 million, possibly, for sure. It could be more. Okay, and then DND says, hi, I fell through a roof at a hotel. I dislocated my shoulder. I had surgery for the labrum tear and the Bankart. 3 anchors were put in. The hotel has a $2 million policy, and I've lost about $100,000 in lost income. Medical bills of $90K. We just got our first offer of $163K, which my lawyer says is a really good offer, and that we should start taking them serious when we get to 200. I feel it's worth way more. Yeah, I mean, I don't know what state you're in, like what city you're in. If you can, add that in, just like what state you're in or what city, just generally, because I'd be curious. But I mean, yeah, if you fell through a roof at a in Miami, in Florida, okay. Yeah, I mean, if you fell through a roof at a hotel floor, I mean, obviously something is unsafe. The hotel floor people should not be falling. And then you've had a labrum tear with anchors. So yeah, I've settled like anchor cases with surgery like that for like $850, closer to $1 million. And then also if you have lost wages of $100,000. Well, I mean, look, if you have lost wages of $100,000 and medical bills of $90, that's already $190. So they're basically, if they're giving you $160, they're not even covering your lost wages and your medical bills. But what about your pain and suffering, right? Doesn't that have any value? I think the pain and suffering is the biggest part of the case. And they're basically not even giving you, they're basically 30 grand shy of even covering just your medical bills and your wages. But what about your pain and suffering? So they're saying it's worthless? Yeah, of course it's low. I mean, that should be like $850, I think, at least, maybe more. That's a good case. Depends on who the attorney is also, if they're a trial attorney. A lot of these lawyers, they're not trial attorneys, so they just tell you to take low ball numbers because they can't go to court and make the insurance company pay more. So guess what? If you're powerless, right? Imagine, put yourself in their shoes. You're an attorney and you have a $160,000 offer and there's a chance to get 200, but you're powerless to go to court and make the insurance company pay $1 million. So what do? What's the only thing you can do? You tell the client, take the money, right? Because then you get the 200,000. So it's really the attorney acting in their self-interest, but it's not in your self-interest. What I would recommend is that you should, see if they're really, a trial attorney. If they are, let them handle it. But if they're not a trial attorney, then maybe have them work with a trial attorney. Have a trial attorney work with them, or switch over to a trial attorney. I know a lot of really good trial attorneys in Miami. Actually, I'm working on a case right now for somebody. He has like a multi-level fusion, and I was trying to find, and I had like 3 attorneys or actually 4 attorneys that I know in that area, Miami and like Palm Beach, and they're all like amazing. One of them actually just hit for like some crazy, I have to read the email and the listserv. One of them just hit for like 160 million or something, but they're all amazing attorneys. And so, so I would just like have them partner with one of those guys, because it's in your best interest. You're going to get much more. So I don't know who it is, but I'm happy to do a verdict search and just email you all their results, all their settlements, verdicts, just so you have full disclosure. Because I feel like, sometimes they put the wool over people's eyes. It's just not right. People should know. Okay. Nayslayer says, very helpful. Attorney Arkady is amazing. Oh, thank you so much. Amiri says, why would a litigation paralegal not respond to emails and phone calls? I don't know. I mean, like, litigation paralegals should respond. I mean, maybe they're busy, or I'm not sure exactly. It's hard for me to say like why someone else doesn't do something, but definitely, reach out to me or reach out to the litigation paralegal, reach out to the attorney, and they should definitely respond. And I think communication is important. That's one of the most important things. Sometimes, look, I'm busy. Like when I was in those depositions for 7 hours, I couldn't respond, those 2 days. And it was like back to back, 2 different cases. I was like basically tied up for 14 hours, so probably didn't respond. But like I have other people in my office that help. And Felipe says, hey, Arkady, hi, how are you? And DND, oh yeah, he said Miami. Nayslayer says, Mr. Miyagi, I mean Arkady-san, I am confused about liability being censored. My lawyer says if defendant accepts liability, then we cannot mention the DUI and damages. Does this make sense? Well, I mean, not really. It's basically like, I guess what he's saying is if defendant concedes liability, right, then you can't mention that he was drunk, because that goes to the question of who was at fault. But the issue of who was at fault was already decided, right, since he was found not to be at fault. But there's ways around that. Like, for example, if there's any kind of like PTSD or any kind of anxiety, even emotional distress, that you're scared to drive because, you don't want to get hit by a drunk driver, for example. Well, now you can bring it up because now it goes to damages, you see? So there's ways around that. Or you could just bring it up anyway, let them say objection, okay, sustained, but the jury heard it, right? What happened? How did you get hurt? Oh, a drunk driver was drinking a bottle of vodka and slammed into me. Objection, sustained. Well, the jury heard it, it's fine. I wouldn't worry about that. I don't know. If your lawyer is saying that, then that's kind of, I don't know, that's kind of suspect to me. And Come Along with Uncle Joe says, good evening. Hi, how are you? How are you doing? Yeah, so I wouldn't worry about that. I mean, like I did that in a case, like for example, I had a case where they conceded liability, and but I found out that it was like a slumlord, and the slumlord like actually told his manager at the property that he didn't want to pay like $300 to fix some pipe. It was like a corroded pipe that actually cut somebody really badly, and he didn't want to do it because he didn't like a certain type of people. He was like racist, and also he didn't want to do it in addition because I don't know, it was too much money for him or something like that. So he's basically like profits over safety. So I had the client say that, and then they said objection, and then it was sustained because they conceded liability. But like it was really like one of the most powerful moments in the courtroom. I think everyone heard it, and then we got a nice verdict. So yeah. And Nayslayer says, thank you, sir. Oh, no, you're very welcome. And Abby says, will my settlement be in May or June? May. I don't know. How would I know? You have to ask me, you have to tell me about your case a little bit. If I knew that, I'd be like, the Wizard of Oz or whatever. I can't. But yeah, your settlement, I mean, it could be usually, the important thing with the settlement is not really, I mean, I know you want it quickly, but the important thing is that it's fair, right? Because if it's not fair, then you want it to be, if it's not fair, then you want to get fair value. Because if you're not getting fair value, then you're just getting pennies on the dollar, and you don't want to get pennies on the dollar. Oh, he says Kamar. Oh, Kamar Sybil. Oh, yeah, I know. Yeah, but no, your settlement will be later. Well, it's not going to be in May or June. Your case is just filed. We just filed a lawsuit. That's a new case. It's going to take some time, but it could be a good case, but it's going to take time. That case it's a complicated case. It's going to take time. But yeah, we'll definitely do our best and get the maximum on that. But we have to let the process, go through the process. Like basically, it's like you plant a seed and you want the seed to turn into a beautiful rose. But you can't plant the seed and say, hey, where's my rose the next day, right? It takes whatever it takes for, whether it's a rose or a tree, just you have to go through the process. And then Nayslayer says, have you ever had a judge fall asleep during opening or closing? I've seen them, like, not the judge, I've seen like jurors sometimes fall asleep a little bit, not like, not during mine, hopefully, but I've seen it during, like, one time another attorney was questioning a witness and it was getting kind of long. And the attorney thinks that he or she is doing a good job. They weren't doing a good job, but it was just like getting a little boring. And then I saw some of it was like, I think right after lunch, some of the jurors were like nodding off. So it happens, yeah. Okay, I better run. But yeah, this was good. This was a good session. We got about 40 minutes in. Unless there's some more questions, I could do one or two more, but I probably have to go pretty soon. Let me see. Nene says, what happens after the defendant's deposition? Will it go to trial if you actually have evidence, like video footage of the defendant actually running a red light and causing the accident? Well, I mean, look, if you have that, right, just file a motion for summary judgment. That's what summary judgment is like if you have evidence that shows that one side is clearly at fault and there's never there's not a question for the jury to decide. If you have a videotape, right, of a guy running a red light, slamming into you, just sitting there, at a red light stop, then why have a whole trial? You're just wasting the juror's time. So file a summary judgment motion and close the video as an exhibit. You're going to win. And then you have judgment as a matter of law. So now the only question for trial is, what is it all worth? So they can still have a trial, but now the defendants are going to argue, well, guess what? This crash, we're at fault. They have to admit it, right? Because now you have summary judgment. But they're going to say, we're at fault, but this crash is not what caused your injuries. Your injuries were caused from degenerative disc disease, right? Or from, I don't know, normal painless aging process. We didn't cause these injuries. That's what they're going to say, number one. And then they're going to say, number two, you're not that hurt or whatever. You're a malingerer. You're making this up. You're trying to win the lawsuit lottery. They have other defenses to damages, basically, is what I'm saying. So, but yeah, it could still go to trial, but probably not on liability. And then Abby, that's why he's saying it's a settlement close. It's not really close. I have to be honest with you because, like I said, we just filed that case. It's a new case, and I think it's against like the city. It's against like a lot of these shelters. That's going to take some time, honestly. But we're going to try to get, of course, the maximum. And it's not an easy case either. It has like some issues, so we're going to have to work on that. And Nayslayer says, last one I forgot. Does the victim need to show up at mediation? I don't think you have to. You want to be available, at least by Zoom or whatever, because if they have money for you, your lawyer wants to be able to have authority. So, for example, if you want like $1 million, but they have 700, and then the judge says, well, will you take 700? And then the lawyer's like, well, I don't know. My client's not even here. Well, then he's going to get mad. He's going to say, well, what the hell? Where is he? Why are you wasting my time? Nobody wants to get their time wasted. So, yeah, I think that's important. And A224 says, hi, I got hit from behind, my car record. Everything what happened and my deposition is 20 days from now. What's the question going to look like? I already done the discovery and the mediation in June. Oh, so your deposition is in 20 days and you got hit from behind? So they're just going to ask you like what happened, how many lanes of moving traffic, probably ask you, is your car equipped with turn signals? That's what they asked my guy. They ask like stupid questions like, are there any drugs are there any prescriptions that you are required to take that you failed to take? Like, no, I don't know. I think they have like a script. If you watch my video, it's called Super Depositions. I think the thumbnail has me like in a Superman costume. It's like an AI thing. But anyway, just watch that one. It's like 40 minutes. I go through the whole thing. I think I go through the whole, checklist and all the questions. And you know all the questions. I mean, it's not really anything complicated. The most important thing is don't say, as long as it's true, you're not at fault, right? You don't want to be at fault. If you're at fault, that's no good. But you got hit from behind. And then, you want to say like what you can't do. Like if they ask you, what are some of the things you were able to do before that you can no longer do now? If you say, lift 100 pounds, weight, so that's the only thing. That's not good, right? Because that means you can still do a lot of other things. So I like to tell people, you got to look at your own life and do almost like a day in the life. Like I couldn't sleep, I couldn't get out of bed, I couldn't take a shower, I couldn't put on my socks. Things like sleeping, sitting, standing, walking. If you just think of those things, right? SSSW, sleeping, sitting, standing, walking. That's usually comprising like 90% of your day, right? Because either you're sleeping for like 8 hours or whatever, you're sitting, like I'm sitting now, right? You're standing up talking to somebody, or you're walking. That's usually what you're doing. So if you just say those things, that's like a big chunk. But I like to do like a day in the life and give some examples. So I would work on those. I have actually that checklist. It's like 13 pages. It has all these activities. So I can email. I've been emailing that to some people when they ask me. That's helpful too. And Nene says the doctors actually said my injuries came from the accident. So that's good. That's really good. Yeah, that's what you want. You want the injuries to be from the accident. And then Argel says, hi, Arkady, since we are now at a lawsuit phase and the statute doesn't exist anymore, will my workers' comp disability payment continue? It's been 3 years now. I've been receiving payments. Yeah, it should continue. The only time the workers' comp stops is if you do the Section 32, because then you get like a big lump sum, like 300,000 or whatever. So then they stop the smaller payments until I think you spend down the 300, and then it starts again. I'm not sure because I don't do workers' comp, but I think that's how it works. If they get a credit, like they give you a lump sum, whatever it is, right? It could be 100, 200, 300, whatever the lump sum is. I believe they get a credit as if they were still paying you the smaller amount. Let's say you're getting 1,000 every 2 weeks. So they still count it like that, but you wait until that 100,000 gets spent, and then it continues again with the smaller payments. I think that, but don't hold me to it because, like I said, I don't do workers' comp really. Okay, and Upton says, shoulder injury, out of work for 4 months, did a year of physical therapy, only took injections but refused surgery. The driver had 25,000 limit, and I already got that. Now suing UIM policy of 50 that I have. So you're out of work for 4 months, and you had a year of physical therapy. So you've got the 25, and then you're going for another 50. Yeah, so you should be okay. That's pretty serious injury if you had a whole year of PT injections. I mean, if you got 25 from him, but you have 50, usually you're entitled to the difference, right? So you might get another 25 from your own. I don't think you can get the full 50 because he had 25, so you got that, but you have more, so it's the difference of what you have that's greater than what he had. So you got 25 from him, you get 25 more from your own, so the total will be 50. But you should get that. And Good Citizen says, can you talk briefly about e-discovery? E-discovery, yeah, I mean, I don't do too much of that. We don't really see too much of that in personal injury. I don't know what you mean by that. If you mean like electronic, like kind of like metadata and all that stuff, electronic discovery, or I'm not sure. I'd have to get a little more of what you wanted me to talk about. But yeah, I mean, I'm happy to do a video about it or do a little research into it and talk about it. I know that some of the bigger firms, when they have all those, like the big, like the Weil Gosschall or the Cravath, they do a lot of that e-discovery and, all that stuff. Like, but yeah, we do some, like we get, like, for example, I have a case now where they're asking for like metadata because we have a photo, but they're like, oh, the photo, even though it shows the unsafe condition, they're saying, well, how do we know it's that day? It could be taken some other time. I want metadata, but I don't know if we have metadata because we just have the photo. I don't know. We might not have the original. So it's like stuff like that. They fight over that stuff. Defense lawyers just want to delay and fight over anything they could fight over. It's crazy. And Nayslayer says, Arkady is very thorough. Hope everyone feels better. Go to PT. Yeah, definitely get your PT. One Love says, what about if you make a mistake at deposition with the date of surgery? That's okay. I mean, you're not really, supposed to know all these things. Like, it's all in the medical records, right? So that's the best evidence. So the doctor will know the date of surgery. Like, you don't have to really. I mean, it's good to know, like, the date of accident, what day of the week it was, the date of the crash, when you got hurt. It's good to know that, if it was a Tuesday or a Saturday, But you don't have to. Like, if you don't know, you don't know. And then, look, some people, they got it wrong. Actually, one of my clients got it wrong, then he fixed it. But then I was like, look, maybe it's even good that you got it wrong because one of the things we're claiming is a brain injury. So that shows, look, the guy doesn't even remember the date that he got hurt. And that shows it's a real brain injury, right? Because it has memory loss. And then Alex says, how soon can summary judgment be filed? Oh, pretty much any time. I mean, sometimes we even file a lawsuit and the next day file a summary judgment. You could do it at any time. It's basically like, as long as you have the evidence to show the court that you're entitled to it. And then Gambian says, hi, Arkady, I was a passenger in an accident. I found out the MRI that I have 4 herniations, pinched nerve. What is it worth without surgery but epidural shots? Yeah, I mean, it depends where you are. But like in New York, I've had those cases with, like, say, passengers. The MRI has like 4 herniations with nerve impingement. That's serious. And then you have like epidurals. I've settled those. I mean, sometimes quickly, like if you don't even file a lawsuit, they might give you like 15, 20, 30,000. If you file a lawsuit and really fight with them and litigate and do depositions, put it on the trial calendar, it could be even 100,000. Even I think I had one for like 140, 150. I think that was the most for just for epidurals. And then if you go the next level, if you have the percutaneous, which is actually, like, I think the percutaneous is like less invasive and less, painful than the epidural, because the epidural, they use a big needle and they're injecting a steroid into your back. But with the percutaneous, they use a smaller striker decompressor. It's almost like a straw, and they're removing the leak from the disc. So that example I gave you, like this is the herniated disc, the red part, right? So with the epidural, they take a big needle into you and they just inject a steroid like a medicine, kind of like taking a Tylenol for a headache. So now everything gets numb and you don't feel pain. But guess what? The medicine wears off, right? Now you feel pain again. But with the straw goes in, it sucks out this red part. Now the red part is gone, like here, like a healthy disc. And then it's all done under fluoroscopy. So they see everything. So it's very safe. And then it's like, 5-10 minutes, they come out, they're done. And then I've had people do that at like 7 a.m. and then they're construction workers. They go and they work on a construction site the same day. It's not a big surgery. It's minimally invasive, but it is a discectomy because they're removing the injury, the red part, right, the herniation from the disc. So that's why it's a discectomy. And it's like those go for like 500,000. So I would, if you can, maybe get a consult about that. That could be helpful. I mean, I'm not a doctor. I don't know if you need one, but I'm just saying from my experience over the last 15, 20 years, I really think those are better than the epidural, because I've never had hardly anyone ever say, hey, I had an epidural and it cured me. Because the epidural is just masking the problem with medicine. But this is actually removing the injury. So it's better. It's like a win-win in my book, because you feel better, you get rid of your injury, and your value of your case goes up. So like, why not do it? But but not every procedure is perfect, right? Sometimes it's just not for you, right? You might need the full-blown fusion, or you might need something else, right? It's on a case-by-case basis. Okay, I better run, but thank you, everyone. This was good. I like this session. We had a good conversation. I'm gonna try to do one more, maybe on Thursday, probably I could do one. So thank you so much. Have a great night. Please like and subscribe to our channel. Let us know what questions you have. If you want to see a video on a particular topic, just let us know. We'll do one. I'll do some more verdict searches. I haven't done verdict search videos in a while. I'm going to try to get back into the swing of things because, like I said, I was busy with those depositions, but now I still have trial prep to do for the May trial, but I'm going to try to find time to do these videos as well as consults. Okay, have a great day. Thank you so much. And we are here for you. Our goal is helping serious injury victims and families. Okay, bye-bye.